today the Apex Court has said that it is aware of the quote-unquote Lakshman Rekha on judicial review of government policy decisions, but will have to examine the 2016 demonetization decision in order to determine whether the issue has become a mere academic exercise. The Supreme Court, interestingly, today said that we always know where the Lakshman Rekha is, but the manner in which demonetization was done has to be examined. We have to hear the counsel to decide that. A 5-judge bench headed by Justice S.A. Nazir said that an issue arises before a constitution bench, it is the duty to answer. So, demonetization debate essentially being reignited. The Supreme Court telling the centre to keep the demonetization files ready. Arvind is still with us. Arvind, the top court said in an order to declare whether this exercise is actually academic or infructuous, and it needs to examine since both sides are not really agreeable on the manner in which this exercise was done.
Yeah, Rishika, Supreme Court Constitution bench comprising of 5 judges today started hearing a batch of petitions. Almost 58 petitions were filed challenging the validity of this demonetization exercise that was introduced or that was done in November 2016, wherein the old 500 and 1,000 rupee currencies were withdrawn. So that particular exercise was challenged before the Supreme Court, and the matter was eventually sent to the 5-judge bench in order to look into the constitutional validity of this exercise. Wherein central government today told the Supreme Court saying that there is nothing that survives in this matter, and that's why they wanted this matter to be closed, saying that it has just become academic in nature and the Constitution bench should not waste time on this particular case. But wherein the petitioners argued vehemently before the Supreme Court, saying that Supreme Court has to look into the constitutional validity of this entire exercise, because according to the petitioners, that this entire exercise was decided and it was implemented with less than 24 hours under RBI Act, Reserve Bank of India Act, wherein the earlier demonetization exercise, let it be in 1940s and let it be in 1970s, both those exercises were done through a separate act of Parliament, and that's why they said that the Supreme Court should look into the procedure and also the other modalities through which this particular exercise was carried out. And that's why Supreme Court said, in that case, Supreme Court said that they are ready to hear whether there is anything surveys in the matter, and they also asked the central government to come up with a clear affidavit on this aspect, whether there were any procedural irregularities in this exercise. And they also made it very clear that centre should keep the files. One, the agenda note of the RBI's board meeting, and second one, the cabinet note. Both these documents should be kept ready for the perusal of Supreme Court. This is a very important development that has taken place in this case, because all these while the centre, even the under Right to Information Act, these two documents, one the RBI agenda note and also the cabinet note, both these notes were not given to public even in the RTI Act, but now Supreme Court has asked the centre to keep these two files ready for its perusal.